Hello, everyone. My name is Katharina Pistor, and I would like to share some thoughts with you today about organizational law and worker democracy. I come to the table as someone who has been teaching corporate law at an American law school for about 20 years. And every term when I teach corporations, I tell my students that corporate law, or more generally, business organizational law, is the constitutional law of the private sector. Just as state constitutions divide and allocate powers amongst different actors and install checks and balances, so does business organizational law. And either might also protect certain constituencies or interests, the environment, workers, social welfare, one way or the other as well. That also suggests that changing the architecture of firms and firm governance might actually be the first step in changing worker democracy or achieving worker democracy. Let me say a few words about how firm governance is conventionally understood. Most of my colleagues would argue that corporate governance is a set of institutions that ensure that investors obtain a fair return on their investments. And when they say investors, they typically mean shareholders, perhaps creditors, but typically not workers. Workers have contractual rights with the firm, and that's about it. They're not considered investors and not treated as investors. But management is, and management, of course, is technically also a worker. So we can think about transposing some of the protection management enjoys, perhaps to other workers as well. What are the classic governance mechanisms? Voice, exit, and some level of judicial review. And each of these mechanisms varies by constituency. So voice, voting and representation, is reserved typically to shareholders, those who invest money, patient money into a firm. They participate in decision-making unless we have co-determination or other mechanisms that ensure some level of worker participation in governance bodies or at the shop floor level, or even both, which is probably the most effective way to do so. Then there is exit. Can you simply vote with your feet? And in a liquid market, shareholders have an easy exit option, bond holders as well. Management very often is protected for an exit possibility through golden parachutes or golden handshakes, also reserved to some employees and not extended to others. Most blue-collar workers, of course, are relegated to the labor market or to unemployment insurance if they lose their job and have to find a new position. And in the US, on top of that, we have, of course, employment at will as the default option. Judicial review can take different forms. Shareholders might sue derivatively or directly the officers and directors of the firm. Workers and creditors have contractual rights, but also keep in mind that workers very often are mandated these days to use arbitration qua employment contracts over which they don't have much bargaining power. So what are the prospects for change? Contracts can be easily changed if you have the bargaining power to do so. Organizational law also can be changed, especially in jurisdictions where organizational law is enabling rather than mandatory. And that's true for the United States in particular, but increasingly so also for other jurisdictions. We also have a couple of new organizational forms that have been created, such as the public benefit corporation that allows corporations, closely held or publicly traded, to specify certain objectives beyond shareholder value maximization, which they want to fulfill. And there is a movement going on to update old co-op statutes, which have remained dormant, sometimes for decades, because they were not used much and people thought this would be a dead form forever, but this is coming back. But even within existing legislative forms, where we have flexible enabling law, we can even use basically a contract to write the kind of organizational architecture that we want to write. And a classic example would be the Delaware Limited Liability Company Act, which allows you to write almost any allocation of powers, checks and balances into the contract. Now that sounds great. And so we might be able to do a lot already within existing legal constraints. But I just want to add a couple of words of caution here, because true equality, which is the idea behind democracy, true equality is contingent. Of course, even at the state level, we have only formal equality. So every citizen at a certain age gets a right to vote. That's how far equality goes and is protected in classic representative democracies. Also something currently under debate, of course. In business organizations, different constituencies have and are recognized to have fundamentally different interests and make fundamentally different contributions. And the contributions they make have an effect on how much bargaining power they have, especially exposed, but exposed in crisis situations has ex ante implications. So even if we were to better align the rights of workers with those of other constituencies, I think we have to be mindful of the fact that the nature of the contribution varies by constituency, that the relative importance of each contribution to the survival of the firm differs, and that this is ultimately what counts ex ante for bargaining powers. So a firm in distress revives basically the classic conflict between labor and capital, because firms that can't pay their bills will be forced to exit from the market. And that's where the bargaining power of those who fund the firms comes from, and that has to be taken into account as we redesign the architecture of firms. So let me leave this here. I don't have answers yet. I just want to throw up questions, and I'm looking forward to hearing back and maybe debating these issues in the future.